Welcome back to the deep dive. It is Wednesday, February 18th, 2026, and I'm stamping that date right at the top of the show.
Yeah, you have to.
Because depending on when you're listening to this, the world, for a pretty specific group of people,
7.5 lakhs of them.
specifically hundreds of thousands of bank retirees, well, money just changed forever.
That's right. There's a real tension in the air today. The Supreme Court is scheduled to hear a case that's not just about money.
No.
It's about statutory rights, some pretty serious allegations of misleading Parliament, and a debate over what dignity is actually worth after you retire.
I know some of you are already reaching for the skip button. The phrase sounds like peak bureaucracy, the driest thing we could possibly talk about.
It does. It sounds like paperwork.
Because when you read the dossier from the SBI Pensioners Association Chennai Circle, it feels less like paperwork and more like a legal thriller.
Right.
We're not talking about accounting slips, we're looking at missing formulas, ignored gazetted rules, and a battle over billions of rupees.
It's a David and Goliath fight, but with a twist, the retirees aren't saying the banks are stingy, they're saying Goliath is breaking the law.
Here's our mission in this deep dive. To decode why retirees say a serious injustice has been happening for nearly 20 years,
We'll examine the regulation that's become their smoking gun and ask the real question: if the law says pay them, why haven't the checks been issued?
Okay, so start us off, set the scene. Who is fighting who here?
In one corner are the retirees, in the other are the banks, represented by the IBA and backed by the Department of Financial Services.
And the central conflict, it really boils down to one single sentence the banks have repeated for years and years.
There is no provision for updation.
No provision. So basically, we'd love to help you, but the rule book just, it doesn't say we can.
Precisely. They argue pension updation, revising pensions as salaries rise, isn't in the contract and the rules don't permit it.
But this is where our source material just drops a bombshell.
They point to a specific document that suggests that whole no provision argument isn't just wrong, it's factually false.
And this is really the aha moment of the entire deep dive.
The smoking gun.
The source points us directly to the bank employees pension regulations, specifically Regulation 35, subsection 1.
And this is crucial. They aren't looking at the original 1995 text.
They're looking at an amendment, one that was made back in 2003.
Okay, so I want to be really precise here because the legal wording matters a lot.
What does Regulation 35.1 actually say?
I'll quote it directly because the wording matters. Basic pension and additional pension, wherever applicable, shall be updated as per the formula in Appendix 1.
Shall be updated. Not can be if we feel like it. Shall.
Shall is a command. In statutory interpretation, shall imposes a mandatory duty, an obligation.
This wasn't some memo, a sticky note on a manager's desk. This amendment was gazetted.
Okay, for the non-lawyers listening and for me, break down gazetted.
In India, once a regulation is published in the official gazette, it has passed the formal process, been laid before Parliament, and becomes binding subordinate legislation.
Once it has the force of law, Parliament's green light, the banks and administrators can't simply ignore it.
Then how on earth are the banks and the DFS getting away with telling courts, telling parliamentary committees that no provision exists?
That is the massive accountability issue SBI Pensioners Association is highlighting.
I mean, if I tell a judge the speed limit doesn't exist and there's a sign right there, I'm gonna have a bad day.
You are. And they argue this is systematic denial. The source claims the banks have been feeding false information up the chain of command for years.
So the implication is the politicians don't even know the regulation exists.
They point out that ministers in both houses have stated on record that no updation provision exists.
That's an incredibly high stakes accusation. If it's true, it means the executive branch is misleading the legislative branch.
Which brings up a huge question of propriety. The source calls it institutional disrespect.
That is a bold claim, but let me play devil's advocate for a second.
Go for it.
Could this just be a mix-up in terminology? Since banks focus on dearness relief, is it possible they think paying DR counts as pension updation?
You have just hit on the exact strategy the source accuses the banks of using. It's a muddy the waters tactic.
Okay, let's de-jargon dearness relief and updation.
Dearness relief or DR under Regulation 37 is linked only to the consumer price index. It is strictly for inflation.
So the price of milk goes up, DIR goes up, so you can still afford milk?
Precisely. It is a CPI mechanism. It stops you from getting poorer, but it never makes you richer. It's reviewed every 6 months.
By contrast, updation is under Regulation 35.1. It's linked to wage revisions. It's about parity.
Update is under Regulation 35.1. It's linked to wage revisions. It's all about parity.
Give me a practical example. Why is inflation protection not enough? Why does that distinction matter so much?
Okay, imagine you retired as a general manager in the year 2000. Your pension was calculated on your final salary from 2000.
Okay,
Now, fast forward to 2025. A new general manager retires from the same post.
okay,
His salary is just astronomically higher.
okay.
25 years of wage negotiations, productivity gains, market changes. So his pension is huge compared to yours.
So you have two people who held the exact same rank, did the same job, had the same responsibilities.
Yeah,
But the person who retired earlier is making peanuts compared to the new guy.
exactly. And Dearness relief doesn't fix that. It just ensures your peanuts still cost what they did back in 2000. Updation says the value of this job has risen, so the pension for those who held it should rise too. It closes that gap.
That's a clear distinction. DR protects your purchasing power. Updation protects your dignity relative to current employees.
Spot on. And the source argues the IBA repeatedly uses Regulation 37, the inflation part, to avoid talking about Regulation 35.1.
The shiny distraction.
They waive the DR check and say, look, we're taking care of retirees. They get raises every 6 months.
And the retirees are saying, well, that's not the point. You're ignoring the real disparity.
Exactly. They are saying one is for prices, one is for wages. They are not substitutes.
Okay, so the law says shall update. We know the difference between the two types of relief, but we still haven't answered why it's not happening.
This is the missing link in the whole thriller.
Okay,
Remember, Regulation 35.1 said pensions shall be updated as per the formulae given in Appendix 1.
yes, as per the formulae.
Here's the catch. For every wage revision after November 1, 1987, the formulas, the actual math needed to update pensions, were never notified in the Gazette.
And let me guess, the banks say we can't pay you because there's no formula, while at the same time being the ones responsible for creating the formula.
That's the catch 22 the source highlights. Using its own inaction as a defense, we can't follow the law because we never completed the paperwork needed to follow the law.
That seems an incredibly fragile argument. Surely that falls apart under any real scrutiny.
That's what the retirees are betting on for tomorrow's hearing. And this all links to a deeper legal point about what these banks actually are,
Right, these aren't just private shops, they're public sector banks.
which means under Article 12 of the Indian Constitution, they are considered the state.
A state. And that carries a much heavier burden.
It does, it means they can't act arbitrarily or discriminate. Their pension regulations are statutory obligations, not just internal policy.
This reminds me of that legal concept, deferred wages. I've seen the Supreme Court use that term a lot.
It's the cornerstone of pension law in India. The court has consistently said a pension is not a bounty. It's not a gift from your employer. It's deferred wage.
So if it's money I've already earned, my old employer can't just turn around later and say, actually, it's inconvenient for us to pay you the full amount.
Exactly. And just 2 weeks ago, on February 5th, 2026, the Supreme Court made an observation in this very case that has retirees extremely optimistic.
The court cut through the noise and essentially signaled if the provision for updation exists in the regulations, the banks must pay.
It doesn't matter if it's inconvenient. If the text is in the book, the debate is over.
Sounds like the court is losing patience with the no provision argument.
It certainly seems that way. The source document feels very validated by that. It shifts the entire burden from should we pay to why haven't you paid?
Let's talk about the human side of this. Lack of updation over the decades created real hardship.
It's a widening injustice. It creates a class system among seniors. A 75-year-old who helped build the bank in the 80s and 90s is now struggling to cover medical bills.
And the older you get, the bigger that gap becomes.
Exactly. Each missed wage settlement widens the gap. This violates Article 14. You can't treat equals unequally just because they retired on different dates.
Okay, I'm going to put on my CFO hat for a minute.
Go for it.
The banks are businesses, they have shareholders. The argument is always, we can't afford it.
That is the nuclear option defense banks always pull out. But our source comes prepared with the numbers. They've done the math.
What's the price tag?
According to their note, the approximate annual cost for updation, including the giant SBI, is around 3.28 lakh crores.
328 lakh crores. Now, to you and me, that's a lot of money.
But in the context of the entire Indian banking sector, isn't that kind of a rounding error?
It is because banks routinely write off bad loans and NPAs that are triple this amount for a single corporate defaulter.
Ouch. So the argument is you have money to forgive bad business decisions but not to pay bank retirees.
That's the moral argument. But there's also a technical counter to the we can't afford it claim. The source points to another rule, Regulation 11.
It mandates an annual actuarial investigation, basically a deep financial health check of the pension fund.
Okay,
The source argues that since this is required every single year, the banks must know what the liability is. They can't pretend the cost is some big mystery.
and they contend the pension funds are healthy enough to absorb that hit?
Yes, they say the funds are certified as robust, so the financial impossibility defense is, in their view, just another smokescreen.
There's one more angle here that I find really fascinating, the comparison to the Reserve Bank of India, the RBI.
Ah, yes, the parity argument.
The RBI is the regulator, they are the boss, and their pensioners got updation.
So the regulator is taking care of its own people, but the employees at the banks they regulate are left out in the cold.
So, if the parent scheme at RBI has been updated, then logic would dictate that the child scheme at the bank should be too.
Exactly. If the structure is the same, the benefits should be the same. You can't create a caste system where the regulator is protected from wage erosion while frontline bankers are not.
It really feels like a three-legged stool for the retirees. One, the law, Regulation 35 Fund 1, exists. Two, the money, the 3,080 crores, appears manageable.
Uh-huh.
And three, the precedent with the RBI is already set.
And they believe that stool is sturdy enough to hold up in the Supreme Court tomorrow.
So let's wrap this up by looking at the specific demand. What are they actually asking the court to order tomorrow?
It's simple, they're not asking for a new law, just for the existing one to be activated. Specifically, they want the updation formula notified immediately.
That missing appendix.
That missing content from Appendix 1 for all retirees from November 1st, 1987 to October 31st, 2022.
And there's a specific date they want it to be effective from.
Yes, and this is key. They want it effective from March 1st, 2019.
Why that date? March 2019.
That lines up with when RBI's updation was formally approved. It goes straight back to the parity argument, treat bank retirees the same as RBI retirees.
It is a compelling case. This feels different from a lot of our other deep dives. It feels like a real test of the system.
It is. The source ends with a striking reminder. Democracy cannot function if the executive ignores subordinate legislation.
That stops you in your tracks. It moves the whole conversation away from I want a raise to does the law even matter?
Exactly. If Parliament passes a regulation and it's gazetted, but the people with the checkbook ignore it because they don't want to do the math, that's not just a pension dispute. It's a mini constitutional crisis.
Which raises the final question. If a law exists on paper, but the government lets a corporation ignore it, does that law exist at all?
That is the question the Supreme Court has to answer tomorrow.
For listeners in the banking sector, keep an eye on the news today, February 18, 26. The Supreme Court may well reaffirm the long denied dignity of bank retirees in old age.
We will be watching right along with you. Thanks for listening to this deep dive. Please subscribe and share.